And so then the other thing, like I said, is I have a degree in architecture. I'm not licensed. I went straight to law school and never practiced long enough to sit down and take the exam because I knew I was going to be a practicing lawyer. But as a little background, let me tell you how and why I got where I am, why I'm a construction lawyer as opposed to an architect. I will say this, and as we all see much more in the news in the last 5 years, I think the profession of architecture is probably much more of an honorable profession than the profession of lawyers, but there are good and honorable lawyers out there. But a lot of people ask me, and not as much now, but back when I was in architecture school, certainly when I was in law school, and then when I first started practicing, like, how'd you get here? How did you get from architecture to law? If you think about it, and I don't know if you know any of your friends that have gone on from undergraduate to law school and everything, you know, you get your political science major, you have your English majors, you have your other government or econ-type majors that will go into the law. You do not find many architects or engineers that go into the practice of law. And mine is kind of a unique story, at least I think it is a unique story. So when I was very little, I wanted to be an architect. I don't know how many people in this class were like that, but I knew, I drew with all the time. I had blocks and everything else. And in fact, when I graduated from undergraduate school, I went to Notre Dame, the School of Architecture, Notre Dame. When I graduated, my mother had kept some of my writings when I was a little kid, and she took them. And in fact, I just found them again over Christmas because we were cleaning, and I showed them to my kids. And I was comparing the way they wrote in second grade to where I wrote in second grade. It was kind of surprising because my kids write a lot better than I did. But in any event, she took it and she laminated them and gave them to me as one of my gifts for graduation. And there was 2 documents. The first was my autobiography when I was 7. So it was my autobiography. And I had written out what I wanted to be when I grew up. And the second was a drawing that I did that was accompanying it. And it started out, when I was growing up, this was a 7-year-old, when I was growing up, I first wanted to be a comedian, but now I want to be an architect. And then it talked about architecture and drawings and everything else. So I wanted to be an architect since I was at least 7. And then the drawing, which again has a certain, to me, irony, although it's not as applicable now, the drawing was of the world's largest building. And I worked in the Sears Tower, so up until the mid-'80s or whatever, it was the tallest building in the world. So that was kind of cool. I didn't start working in the tower till 97, but so I drew the building that I ended up working on. Now my building was much cooler because it had rockets and it could fly. It was really cool. But in any event, so that was given to me. So I knew I wanted to be an architect forever. But the question is so back to the question, why did I become a lawyer? How did I come to be a lawyer? So I continue to draw, and this is a reference that has less and less meaning now. But I used to watch Michael Brady from the Brady Bunch. He was an architect, so he was like the architect on television. So I was very interested in everything else. And as I got older, and you guys will learn from this semester, I talk a lot. I'm Irish, so I have the gift of gab, and I talk and talk and talk and talk. I'm also stubborn, so I fight a lot, and I don't like to give up my position. And so somewhere along the lines, when I was like 10, 11, and 12, as I had further growing up, people used to tell me, you should be a lawyer. You argue all the time, Hanny, and you should be a lawyer. And I didn't want to believe my press. I didn't want to hear that. So I'm 13 years old, and my father, we grew up in a suburb of Detroit, so he was in the automotive industry. And so he sold to the automotive industry. And he would entertain designers because he would sell products for the interior of cars. So some of his entertainment would take the senior designers from General Motors and Ford and then Chrysler and AMC. He would take them out, dinners and everything else. But every year he had a fishing trip down to Lake Erie. And it was a bunch of guys, and they would go down and drink beer and draw minnows and really didn't care about the fish, but that's what they did for a weekend. 13, I was old enough to go, so that was kind of cool. And I'm out on the boat, middle of Lake Erie, and on the boat is the senior chief designer at General Motors. He is the #1 guy designing the cars. Way back before they did computer modeling, when they would do cars, they actually carved them out of clay. They had full-size models. They would build a frame out of wood, and then they would slap on the clay, and they would actually sculpt these cars. He was one of the guys that did that. His gentleman's name was Larry Yeager. And To his credit, he saw this 13-year-old boy sitting in the corner of a boat with a fishing line in, because obviously he wasn't hanging out with the guys drinking and having the fishing trip. And he saw that I was not really having a good time. So he came over, very nice, and started talking to me. And I had known who he was because my dad introduced me to him. And I was kind of a little bit starstruck because, when you're 13 and you're a kid and you're in Detroit, meeting the guy that designs the future cars in the world, his stuff was space age. That was really cool. So I started talking to him. He's telling me what he does. And he's like, well, what do you want to be? And I said to him, I've always wanted to be an architect. But everybody tells me I argue all the time. And they tell me I should be a lawyer. And he looked at me and he said, Mike, architects need lawyers too. I was like, oh my God, there was this huge light bulb that went over the head. So me in the middle of Lake Erie with Larry Yeager at 13 years old was when I decided I wanted to do what I do today. So it's a weird story. It's unique, but that's how I got here. I don't know what I've been able to figure it out if I hadn't gone on the fishing trip. Who knows? But I love what I do. I represent architects and engineers all the time. I also represent owners, which if you had to pick, and there are people that will be listening to this lecture later on that are contractors. To them, I apologize. But if you had to pick, I like the design side and the owner side than the contractor side. Contractors kind of get a little more aggressive. It's a different business world. I like design. I like the creativity of it. I like working with the owners because the owners are the ones that have sometimes the vision, and they go to the architect to help me translate their vision onto paper and into 3 dimension. So I represent principally design professionals and owners. I have worked on all different types of projects, of everything from small kitchen renovations to billion-dollar projects. I think most of my wheelhouse runs in the range of $30 million to $350 million, but I do all things. How many people in the class have been to Navy Pier in the last 2 years, 3 years? So I'm Navy Pier's attorney. I did all the contracts for all the design. I worked with James Corner Field Operations, which is the architect and their team. It was actually 14 different design professionals on that team. So we started that project back in 2011, 2012. We got into negotiations with, it was an international competition, brought in a lot of architects in the competition. James Corner Field Operations, they end up winning it. I wrote all the contracts for that. Then we got into the construction phase. I wrote the contracts for the first contractor. There were problems with that contractor, so we had to get them out of that in litigation, so I handled all the litigation issues with that. We brought in a new contractor. I helped them put up the Ferris wheel. I did some of the limited, not much of the negotiation, but some limited in the new hotel that's out there. So that's one project that you guys could see that I worked on. I did some work on the hospital Rush. I did some of the Rush stuff. Trying to think what else you may have seen over the years that I've worked on. I work on the biggest projects I've worked on. The billion-dollar project was a power plant, a series of power plant projects that we've done. So with the EPA and other things, you have to do back-end cleaning of the coal. So we work on back-end power plants and the infrastructure for that. Belmont horse race, where the horse race is at, they're actually in the process of doing a renovation. I worked on the contracts for the horse track, for the track architect, and the renovation of all the clubhouse. So I do everything from soup to nuts. High-end residential. I've worked on residential projects. Not the largest, well, maybe largest square footage. The highest dollar value residential project I worked on was $68 million worth of construction for a series of projects, residents. There was the main house and the guest house, or the cottage, they called it. The cottage itself was a $22 million build. There were the stables for the horses and their artwork was $10 million. And then there was the shed. They called it the shed. It was a $600,000 building that they stored stuff in. So I've worked on high-end residential. Like I said, I've worked on kitchen renovations. I do everything. And one of the things that I like to do is speak and communicate with the architects and talk to them about their design and why what they're doing is important and how we translate that into the contracts, how we make sure the owner's ends are needed, the architect ends are needed, and the communication that go back and forth between the architects and the contractors. So that's how I got here. So that's a little bit about me. You don't need to share about you guys, how you got here, but if you ever want to, feel free. So with that, let's talk about the class. So first of all, the first half is going to be much more theory. much more basis of the law. Like today, we're going to be talking about separation of powers and Constitution and some dry stuff from back in high school. But hopefully it's not that bad. But I just want to give you a refresher course to give you some foundation of where things will be when I ask questions later on. So you understand why a contract and a provision in the contract may have applicability outside of the two parties that are in the contract. How does it affect society? So I'm going to give you some of the foundation. So that's going to be through the midterm. And there'll be, I think it comes up later on too. Second half is going to be much more practical application. We're going to have lectures about how an office works. Like, how are you going to, if you want to make your budget, if you're going to open your own shop, let's say you're a 4-person firm with a receptionist and an office manager, and you have to have insurance and everything else. How do you do that? What do you need to do? So we'll have a whole lecture on that, a whole day on that. And we're going to talk about some practical applications of when the project is out in the field and how it's actually delivered from the design concept, not just contracts, but what are the payment structures? Like how do people get paid? And what happens when there's a problem with payment? Or if there's a dispute, what do we do with that specifically in the real world project? So that's going to be real world stuff. I will be trying to sprinkle some of that in the first half so it's not just all dry. And I try to give as many examples. One of the things that I think is the most important in a class like this is to give you guys examples so you understand contextually. Have you said this? What does that mean? And how does that work in real life? So that's how it's going to be structured. So you have the syllabus that's got my contact information, it's got my lecture topics, and then it'll have the key documents for the class. I already went over that. As I said, really the only two documents you really are going to need is the B101 and the A201. Those are online. You can download. Just go to the AIA.org and you can download those, or you can. They're all over. And for those classes, you can do one of two things when you're going to do the lectures. Virtually every paragraph in those documents will be a slide. And we'll go through those. The slides are highlighted to where the important provisions. I'm not expecting you guys to memorize a 44-10-page font, 44-page, 10-font document. I'm not expecting that. But there will be certain provisions that I will, as we're going through it on the slides, will highlight. So you can do one of two things. You can actually bring in the AIA itself and write in the margins and highlight and stuff like that. Or, like I said, the slide packet. But it's going to be, for the A201, it's a two days we talk about it. There's about 100 slides. You can write right on the slides. So that'll the paper printouts. That's probably the easiest for that. So with the key documents. So for reading, the only one you have to read here is the AA documents. The class is lecture based, and I will tell you this. As I said, I record everything. Right now, hopefully it's recording. Yes, it's recording. I record every class. And so what will happen is, probably not this afternoon, but on Monday, what I'll do is I'll get back to my office. I'll download this into the firm's system. And so when you guys go online on sometime next week to pull up the lecture notes for next Friday, you will see today's lecture notes and you will see an audio file. And that audio file is an MP4. You can just download it. They're anywhere between 6 and 10 megs. And then listen to them if you can't make class. For the last 7 or 8 years, I've taught on Monday morning. And that class started at 10, a little bit later than this. But there was Monday morning, especially if you guys are working over the weekend. And when we get down toward the end of the semester, when I know you guys are getting closer to your presentations, and everything else, sometimes studio takes precedent. I get it. And so you'll have to miss class. That's what the lectures are for. That's what they were originally intended for. Now, like I said, they're all over the country. But I want you guys to understand, this is the school of architecture. And even though I'm a lawyer and I'm going to teach you stuff about the laws, this is not a law school. So I don't treat this class. It's not that it's not as important as everything else out there, because I think it's the most important class in your curriculum, of course, because I'm teaching it. But the reality is you guys came here to go to school of architecture. You came here to learn about architecture and design and theory. My job is to give you an introduction and help you understand and learn about this stuff. My job is not to bring down your grade. My job is not to interfere with what you guys are trying to do here. So, I understand if people don't come to class. I will tell you for sure, if you're at class and listening to the lectures after 8 or 9 years, you will do better in the exam than listening to the tape. It's just, and they have lots of studies about whether you listen to an audio file or you hear somebody talk in person, you'll do better. So my encouragement is to come to class and participate and ask questions and kind of get into it. But if you have to, you can miss it. I understand. And that's just the way it goes. The other thing I will say about this, and I think it's on the next slide. So, we talked a little bit about grading. So the grading is, we have 2 tests, just 2 exams. I don't know how if you guys do for your other non-architecture classes, how exams go, because I know most of it's based on your presentations and your projects. Law school is similar, only law school you have 1 exam. So at least I give you 2. So we have a midterm and a final. It's open book, open note. I don't allow headphones so you guys can talk to each other or send texts and everything else. But bring in your computers, bring in your notes. There's no reason, because I'm going to be covering a lot of information. And so you're going to need it. So you bring everything into to the exam. We'll have an exam, we'll have a review, and you'll know what's coming up and everything else. But it's open book, open note. No homework, which is good. Just come and listen to me every Friday. I know it's Friday morning. They wanted to start it at 9. I got you guys to 9:30. I want you to know that. Because they're like, there's no class space. We have to move you this and that. I'm like, if you want to be in Stevenson, we'll start at 8:30 or 9. I'm like, geez, can you get 9:30 for these guys? So we got you 9:30. So, lecture-based, like I said, no book, 2 AIA forms. This is one of this one and this one. Opportunity and $1,000. Opportunity to raise your grade, C above. So, if you take your midterm and you get a C, and you want to get a B, here's what you do. You send me an email. You say, Mike, I got a C, I want a B. I'd like to write up my grade. The 7 topics that we're going to talk about between today and your midterm, pick something from those 7 topics. I want to talk about what a tort is, and we'll talk about torts today so you understand what that word means. I want to talk about what a tort is. I want to do an article on a tort. Give me a subject. You're going to send it to me and be like, okay, how about we narrow this? I'll help you. We'll have a tough subject. You write me a paper, double-spaced, 3 to 5 pages. As long as you don't have major misspellings and you actually say something to me intelligent and it doesn't look like you downloaded it from online, which has happened, by the way, and I've caught 2 people over the last 8 years, I will give you a B. You will go from a C to a B. It's that easy. It's a paper that should take you 2 to 3 hours. That's it. So if you get a C in your midterm and you want to get a B, write me an email. I'll get you a B. If you got a B and you want to get an A, write me an email anyway. I'll let you write a paper. It's going to have to be a little bit better, but I will go from B to A. So, I don't want to screw up your grades here. You guys are all out there, you're doing design, you're everything else. Like I said, this is not a law school, so my job isn't to make sure that I bring down your grade. Here's the other reason why this is important. I've been doing this for 8 years. Your midterm exam is about 40 multiple guess questions. Your final is about 35. The best anyone has ever done in the midterm of the 40 to 45 questions is like 34. No one has ever got 100%. Because still, as much as I try to talk like you, I still write like a lawyer, and my questions are like a lawyer, and I think they're confusing. And I try to clarify. I would love to get 100%. I would love somebody to get 100%. I don't write the exam to make it really exceptionally hard. It just happens. So, as a result of that, there are people that actually try really hard and they don't get good grades because they don't understand it, they don't connect or whatever. And so there are C's sometimes. So I want to make sure that and the way I write my midterm, I think people tell me I'm a good teacher. People tell me that they like how I explain things. I get good reviews. I get people from all over the country emailing me. I think I'm not the best exam writer. That possibly could be it. Or maybe I'm a tough exam writer. Either way, I want to make sure that I do not affect your grades here. So this is important. And here's the thing I really strive to. I want to tell you guys this. Here's what's going to happen. Some of you guys are going to get C's in the midterm. It's just going to happen. It's happened every year. And you're going to want to write a paper. You're going to send me an email. Or maybe you don't send me an email right away because you're busy. You got other stuff going on. And you're not going to write it. And then all of a sudden you're going to get to the last week of school. And I'll take that paper all the way through till I have to turn in grades. So for the midterm, all the way till I have to turn in. Because for 2 to 3 hours for you to write it, 15 minutes for me to read it and grade it. So it's a cake for me. And for that, I'm a pretty easy grader. I'll just tell you that. What ends up happening is every year people they reach out to me, we set a topic, and then I never get the paper. And then I have to turn in their C at the end of the semester. And it kills me. So, If you want to do that and it's midterm, knock it out right away. Don't wait till the end of the semester, because I will also take the same thing for your final. Your final's going to be taken. It'll be graded. You will get your results the next day. And you're going to have about a week and a half before I have to turn your grades in, or maybe at least a week. I'm not sure which. And you can write me a paper then. And finals, you guys are going to be going crazy. There's going to be a million things going on. And if you have to write 2 papers now, and that's what often happens. What happens is I get somebody, they have a C, and they're like, oh, I wanted to get a B. They don't write it. They take the final. They get a B, or maybe they B minus or whatever. And they're like, I don't have time to write 2. And they're like, I'll just take the B minus or the C or whatever I take. And so, because they don't have time. So if you get and even if you get a B and you want to get an A at midterm, do it right away in the first week or so, because then you'll forget. Just do it. And I'll get you a better grade. So, I mean, how hard is that? Okay. Attendance is critical, like I said, for full understanding. Like, I have the lectures online and everything else, but you guys will do much better if you're here listening to me ramble on. Like the lectures are posted on the website. Last point, $1,000 for the person who has the best grade in the class. Now, that's not the write-up after I send my paper in. I got a B and I write up to an A. The best raw score of the two tests, you get $1,000. Come on, that's good. Pretty good. Just come to lectures, listen to me talk, bring your notes into class, and fill in the blanks. Come on, not too bad. Okay. And the questions, the exams are multiple guess. Some of them are true-false, but the majority, let's say, if it's 40 questions, I'd say half a dozen of them true-false. The rest of them all A, B, C, D. If you'll, I think, wait, is it on here? Wait, no, it's not here. So on the, you'll see on your syllabus, I think it's March 12th, the pizza party, whatever day that is. So the exam will be on a Friday. The following, I think, Tuesday or Wednesday, whatever I set. And if it doesn't work with your schedule, we can be flexible. You're going to come down to my offices. You will see something else that I did. I actually did the design work for our lobby, our conference center. I'll buy you guys all pizza and dinner and everything else. You guys bring your own beer and wine. I'll have sodas and everything else, but I'll buy you guys dinner. I'll give you a tour of my firm, and you can see I bring my portfolio that I did in college. Like, you can see the drawings and the designs that I worked on, and we go over the exam for the midterm. That's actually pretty fun. I work on the conference rooms on the 71st floor of the Sears Tower, so spectacular views. We have what I have been told. I don't know this because I don't walk around other law firms. We have one of the premier curated art collections. We have some Picassos, Miros. We have a Corbu. We have who else do we have? But we have a number of really nice pieces of art that I can show you that we have. It was one of our partners decades ago. His wife was a big collector, and when they passed away, they donated a lot of them to the firm. So we'll give you a little tour. You can see that, and it's a nice night. So that's one additional. It's not mandatory, but it's fun. You guys can come down. So that's an extra class. But that's okay. So, all right. Objectives of the course. I've been talking a little bit about. The first thing, one of the things I want you guys to understand the jargon, the lingo. We got all these legalese out there. Why, fors, whereas, is, everything else. What do these all mean? But more importantly, like when they're talking about what's a tort. How many in this room have ever heard the word a tort? What's a tort? You've heard of tarts that you eat, but so there's one person. So nobody's heard of tort. You're going to learn about what a tort today is. So I want you to understand the jargon. The reason why is because when you get out there and practice, like I said, these terms are going to come up, and at least you'll have a better understanding. Every person, my goal is that every person in this class, sometime in the next 10 years, goes, oh, I remember that from class. I remember this. I'm glad I got that. That would be the greatest thing is that if everybody one time just said, that was cool, I remembered it way back in 2019 when Hanahan was yelling at us for weeks on end. That would be great. So I want you to learn the jargon. Okay, I want you to understand part of what we're going to talk about is types of practices. So when you get out there as an architecture firm, there's corporations, there's partnerships, there's LLCs, there's LLPs, there's all different things. So let's go ahead and talk about that. And this is over the course of the semester. We're going to understand dispute resolution, courts, mediation, arbitration. Today we're going to talk about that specifically. What happens when the parties don't agree, and how do you resolve that? That's what this is, dispute resolution. Understand business agreements and contracts. I mean, at the end of the day, we're here, most of you guys are here because you have this creative design input and intent, and you really like that. But when you're out there, after you finish, after May, now you're going to go out in the business world. You're going to get a job. How many people here already are working in a firm? So a couple. That's good. And by the way, every year, I think pretty much every year, people have come up to me, whether they freelance themselves, maybe they're doing some design work on the side, or they're working with them. They come up and they're like, "Oh, Mike, I got this," and it's a real question that's going on in their office or their own practice, whatever you want to call it. Just ask me, I'll help you out, whatever you need, no charge. Okay, so I want you to understand business agreements, because at the end of the day, you guys, what the structure, the basis of all this is the owner hires the architect and the owner hires the contractor. Well, there's some kind of business deal between them. It's not just because I'm in this building and I'll pay you money. There's all these terms and conditions about what everybody's supposed to do. Same thing with the owner and the contractor. And then what's the relationship between the architect and the contractor? Is there a relationship? We'll talk about that. And the agreements all establish that. Okay. We're going to talk about how the practice of architecture is regulated by the state and others. That's going to be today as well. That's kind of the separation of powers and who does what. And we're learning and understanding the architect's professional practice responsibility. So one of the things that a lot of people don't understand when they're at this day and age is you guys have a responsibility to the public, to general public out there. And it's the very base core, as simple as it sounds, you got to design a building that's safe and that's not going to fall down. Okay? Sounds pretty simple, but then you get into complexities when you're building complex structures and you have them. I know I don't believe in the grad school, but I know when I was undergraduate, I had to take structural mechanics, mechanical engineering, civil engineering, all the engineering stuff. So you have this obligation to the public to build something that's safe, not just cool and creative, but safe and functional. And so how does that professional practice responsibility factor into that? So we'll talk a little bit about that. Can you get sued for violating a public standard? Or are there issues in the business relationships you have? There's fraud, there's all these things that come in, and what are the ramifications of that? We're going to talk about the economics of architecture and real estate development. That's going to be a whole class called, as you can see in the syllabus, pretty creative, the economics of construction. Pretty creative. It's going to talk about how, if you want to develop a building, I'm going to have a building, a type of a building. I think in this example, it's a 100-unit condo building. And I'm a developer. How much money do I need? How do I do the debt service? How do I pay for it? What happens over the years? What's that 100-unit building going to cost? And how do I recoup that? How do I recover money? Is it going to be condo? Is it going to be apartments? So we're going to have a whole day talking about that. And then finally, where's your place in the business world? Where do you fit into this chain? The owner's king. They have the money. Contractor thinks that they're king because they're the ones that build it and they can't do it, and contractors treat themselves like king. Where do you guys fit into that? How does that all structure work? And that affects, going back further up, the business agreements. This is the structure where you are sitting in the world. Any questions? Excellent. Okay. Real stuff now. So, we're going to talk about just generally an overview of the law. And I said, and what's funny is, I was actually talking with one of my partners just this morning because he was looking for a document from me, and I'm like, I got to go teach. He's like, what are you teaching today? I'm like, well, I'm going to teach him about the law, the basis, and I said, the problem is, like 5-8 years ago, a lot of the stuff we're going to cover today, nobody knew about, but there's so much in the law. I don't know how much you guys watch TV, like the news channels, but they talk about this crap all the time, separation of powers and blah, blah, blah. So some of it you guys will have heard today, but that's where we're going to go. So let's talk about here. Okay, so we have the laws of nature. And actually, the reason why I put that up is like, well, why is that relevant to architecture? Well, it's the first law that you guys have to recognize. You're going to build a structure. Gravity will pull it down if you don't do it correctly, or wind loads. And the fact of the matter is things like the Sears Tower that I work in, the shear forces, the horizontal shear forces, are much more important in the mechanics and the engineer of that building than the gravitational forces. So as you get higher, you have different forces. Those are the laws of nature. Those come in that are affecting what you guys do for practice. So that's one of the laws you guys have to think about. Okay. After that, then the laws started coming in as how humans handle things. So we have monarchies, the king, they get to decide everything. And the kings for years and years, and the royals are the people that that developed high architecture. If you go back in time, and I don't know how much you guys go back and do historical in your course structure here, but for me, when I was undergraduate, my third year, I lived in Rome. I lived right downtown. I was 4 blocks from the Pantheon, 6 blocks from the Forum, and I lived in a building that was right next to one of the largest churches, San Andrea della Valle, in Rome. And beautiful architecture was done by Borromini, has the largest, I believe, the second largest dome to St. Peter's in Rome. And those were built by the popes, and the papal royalty. So while it wasn't a monarchy, I mean, if you think about it, the money that was there and everything else. Interestingly enough, and these are some of the things you learn when you live there, so the professors for the School of Architecture, they lived in a different building. That building was built and owned by the Pope's son. Yes, back then, even though they were supposed to be celibate, everybody knew that the popes had sons and daughters. They didn't take the same name, but what you would tell is you would walk around these buildings, and the professors that taught our school, the papal seal is on the building. And you go back to the historical records, and it was built and owned by someone that didn't have the name of the pope, whatever the pope was at the time. But the fact that the papal seal was on there meant that they were family related. So it was built by the pope's son. So the whole, priest-celibate Catholic thing, they didn't really apply back in the 15th century. But that's who let and build architecture. Now, of course, as I say, it led to tyranny because at some point in time people were like, you know what, I just don't want to only listen to the kings. So that developed other types of issues or other types of structures, and we created what is the pure democracy. Now, as we all know, everybody talks about the United States as the greatest democracy experiment in the history of the world. And this is something that you guys probably do know. We're not a democracy, we're a republic, actually. We have democratic virtues and values and things that are part of how our democratic society works, but we're a republic because it's not one vote, one person, and everybody gives. We elect representatives and senators, and they are the republic. That's why I pledge allegiance to the flag of the United States. One republic under God. So it's a republic that we live in, but a pure democracy was like what they did in Greece. In Greece, in Athens, everybody's vote counted, 100%. So that's a pure democracy. We are a republic. And then we have, as a different type of law as far as the way countries are run, there's socialism, communism. Communism is obviously, we know, was the Soviet Union for many years. China and other states are still communistic countries. Socialism, in some form or another, are in various different societies everywhere, from different European societies. Canada has a certain socialistic bent to it. I'm not going to get into the geopolitical and your government classes and that. Just to understand that that's how, as society started to develop, we came up with different types of laws and structures of governments, but those governments still led to the development of different types of architecture. So if you go back to a communal state, if you think about like the Pueblo Indians and the communal states and what type of, both not just necessarily geographical, but if you take a look at the way the cities are organized and the communal states of how those cities operate, those were based on some of the way the societal and governmental functions of how those tribes operated. So there's different inputs and that affect ultimately architecture and how architecture progressed over the centuries and from what you guys look back at and what you study. Okay. Here, like I said, we're a republic and a constitutional democracy is another way you could call it, because the Constitution creates the republic, but the democracy says we vote. So we do have certain things. We all vote for the president. Or if you're within a state, you have the statewide election for your 2 senators, and then when you're in your congressional district, you have your congressional. So it's a democratic voting process to elect that individual to have your representation. So it is our form of government. The majority does not always rule. We understand that very well. I try not to make political statements one way or the other. I guarantee you by the end of the class you will see what side of the political spectrum I talk on or I lean on. But it's not because I'm here to put anything down your throats or whatever. It's just sometimes we all talk the way we are. But we've always heard, that the popular vote didn't win the election, the last presidential election. That's what they say, 3 million people. It's not the first time. It's actually the 4th or 5th time, I believe, in the history of our government that the popular vote has not won. And that's based because we have this electoral college system, and some other things. That's why you don't necessarily need the popular vote. And whether the electoral college system is still applicable today is an ongoing question. Does anybody here know why we have the electoral college? So, I'll give you a quick, teeny little history lesson. So we go back to the time of the North and the South, before the Civil War. The South had many more people, but they didn't vote because they were slaves. If you had slaves, your slave counted as 3/5 of a vote, even though they didn't vote. So they needed to have a way to balance out and equalize, because you would have a landowner that had acres and acres of land with 3 or 4 people in their family and then a number of slaves. And so they made the argument that I have more people, so I should have more representation than the number of votes. And so they came up with a system that said, okay, well, this person's vote is worth 3/5 of the vote. And then they had to then have this electoral college of people that became the representatives of what the state ultimately voted. And so it was largely developed due to the difference between the agrarian society and the industrial society of the North and the South, and how the populace was. So the electoral college was a methodology of evening out the populaces of the state. And what's the interesting thing is, if you are one of the people that does the if you're in the electoral college, which is a number, there's actually people that are casting that vote. You do not have to, by law, follow what your district went with. Now they almost always do, but if you go back to the election, I think it's the 1976 election. I think Reagan was elected in 1980 or 84, whichever election he was elected in. Maybe it was 84. So maybe in the 1980 election. But the election cycle before Ronald Reagan was elected, if you go and look at the electoral college vote, there will be 4 votes for Ronald Reagan. He was not a candidate at the time. He had been in the primaries, but he ended up losing out to whoever, and I can't remember going back that far. But the remainder of the electoral college is split between the 2 presidential candidates, of which the one won, and maybe was it Carter? Yeah, it was Carter. So Carter and Ford were the 2 people that were running, Jimmy Carter and Gerald Ford. And there's however many Carter got, however many Ford got, and there are 4 electoral college votes for Reagan. He wasn't even on the ballot. So the electoral college does not have to vote with it. It's an antiquated system, has good balance. Dad, if you're the winner and the recipient, it's the best. If you're the loser, it's maybe not the best. But that's what we have. So it doesn't always rule. It doesn't always win. Democracy, it's our democracy, majority doesn't always rule. The other thing is you may elect your representative or your senator, and you believe that their platform is X, Y, and Z, and that's why you elected or voted for him or her, and then they get to Congress and they do something different. I'm like, well, that wasn't what my voice was, and that's what you didn't promise me, that campaign promise. Well, ultimately, the majority thought that they were going to get an X policy, but the individual who represents a state, whether it's a representative or a senator, can make their own decision. And that's why we have this what's called a constitutional democracy or a republic, is because even though the majority thought policy A was going to go in, the senator or the congressman can still do what they want. That's good or bad. It is our system. It seemed to have generally worked over the years. It's being tested now, but it seems to have worked generally. So, our system, though, was to and should have been, it was designed to protect the rich and the poor, trying to get each person to have a vote. Whether you were rich or you were poor, your vote was one vote when you were trying to vote for the people that you were going into power. Obviously, there was the issue back when we had before the Civil War, slavery, that they didn't get equal votes because they were only 3/5 of a person. That changed after the Civil War, thank God. But that was the purpose. One of the purposes is to make sure that everybody has a say. That's drawing from the basis of a true democracy, is one vote, one person. Like I say, it's a little bit different in ours, but that's the purpose. Okay, and just so you know, even though I spent the last 10 minutes on it trying to talk and stuff, none of this slide will be on the exam. I'll give you tips here and there where stuff will be in the exam. There's one coming up I will tell you I guarantee will be in the exam. I'll let you know that one too. Okay, so like I said, we're national. This is the national government. Even though they talk about federal government, there are laws. We're talking about laws now. So we are a federal government, but we have national laws. National laws, they're expressed only if it's granted to by the Constitution. If it's a law that affects everybody in the land, it only can happen if it's considered constitutional. And that brings into our tripartite government. The Congress, whether it's the House of Representatives or the Senators, they pass laws all the time. And whether it's on the national side or we get down to a state side, laws are passed all the time. And then they're either signed into law by the governor if it's a state or by the president if it's a national law. That doesn't mean that law is valid. It could be unconstitutional. So we always hear about, well, it's going to the Supreme Court. And that's one of the purposes of the Supreme Court, is to test to see if the value or the law and what it says is constitutional. You always hear about, maybe not always, but you may have heard about how the Supreme Court has decided not to take a case. It's not because they didn't think it was interesting. And it's not because it's not a unique issue that's before the court. They don't take the case because it may not have a constitutional or national question involved. So, like I said, a lot of this is so much in the news right now. You think to yourself, okay, so how did a federal judge in Pennsylvania rule that some travel ban was barred nationwide? How can one judge in one district, even though he's a federal judge, or she, I don't remember which one, there was one in D.C., there's one in Hawaii, there's various ones. How can that one judge make a decision and say this decision applies to everywhere in the country? Well, the reason why is because that federal judge is looking at a national law. So the law was written for the whole country, and that federal judge is going to say, even though I'm sitting in the Western District of Pennsylvania, the district of where I'm a federal judge, if I said that it's unconstitutional for only the Western District of Pennsylvania, that would not make sense because it's a national law. So that judge is looking and saying, the Constitution says you can do X, Y, and Z. This doesn't fit in the Constitution, so I strike this law on a national basis. And then the people that lose that argument, they take it up to the Supreme Court because you have to get, finally, the Supreme Court covers the laws over the whole land. The Supreme Court has to say, well, we agree with that judge in Pennsylvania, or we don't agree with that judge in Pennsylvania. Sometimes they decide they're not going to take a case because it doesn't have a constitutional issue. So there's a recent case in the law, right, in the news. This actually came down today. There was a discussion about what's in the Supreme Court. They are discussing it right now, their morning session. There's a company, nobody knows the company. It's a foreign company that has refused to supply documents in response to a subpoena from the special counsel. They have had secret briefs and hearings. Everything's been redacted. Nobody knows. We know the law firm for this company. That's all we know. They, at somewhere along the lines, I don't know if it was the trial court or the appellate court, because there's trial, appellate, and the Supremes. Somewhere along the line, there was a sanction, a monetary amount, that for every day that this foreign company refuses to produce documents in response to the subpoena, they would be fined. And I think it's like $50,000 a day. And so there was a challenge to that ruling. There was a challenge to the ruling of whether they had to produce documents and some other sundry challenges. The specifics of whether they have to pay the fine or not went to the appellate court and went to the Supreme Court. The Supreme Court denied to hear arguments on whether they would be fined or not because it was not a constitutional issue. So whatever the ruling of the court below stands, because the Supreme Court says, I'm not going to listen to you, that means whatever the next level down. So this company is now being fined $50,000 a day or whatever the amount is until the decision is finalized. And today they are arguing about another issue, and they're going to make the question of whether they're going to accept the case, is whether the briefs on the big case of whether they have to actually produce documents can be filed in the United States Supreme Court under seal, meaning that nobody can see them. The Supremes may decide today to, again, not accept that argument and not hear argument on it, and so the court will below, because it may not be a constitutional issue. So that's what's going on at national level. Other things. If it's not a national thing, if it's not in the Constitution, the way our structure is of our government, our laws, is everything is then reserved for the state. And so that's when you hear about lawmakers talking about, well, we're overregulated. Why do we have the federal government regulating everything? The states can handle that. And that's part of our structure. We have the national, we have the state. And you guys can figure out what you want to do in your state. If you want to do this in Kentucky, fine. If you want to do something different in Illinois, fine. And if you want to do something third in Colorado, fine. That's okay. Biggest debate on that separation between what's reserved for the state and national, Colorado and a couple other states legalize marijuana. Now, there's many states that have legalized marijuana for medical purposes, but not all. But Colorado, you can walk into what formerly was called derogatory a head shop. Now you can walk into a pharmacy and buy dope. That's regulated by the state. There is a federal law, a national law, that says it's illegal to sell marijuana. So Colorado is technically in violation of the national laws, but they have said, people have kind of ignored that and said, we're going to let that go down to the state. So that's the separation of how states handle things, commerce, and the national laws. Constitution can be broad in its application, and the Congress and what Congress can do with it. So the Constitution, if you want to think about it, well, it's got the 26th Amendments, and there was the original Bill of Rights, was the first 10. Those were the first amendments to the Constitution. Well, it's very specific what it says. It's this kind of amorphous document. So if you had the same case argued 50 years ago before the Supreme Court and what you argue in front of it now, I guarantee you we're going to have a different ruling. And that's because they're human beings on the court. And that's because society changes. One of the biggest Supreme Court rulings that have come down in the last decade was the fact that you could have same-sex marriage. That is now the law of the land. You go back 40-plus years, it was Roe v. Wade. There's lots of things, but all those become in flux. As the court changes, as things different, is the law that we thought was constitutional because of the way the people look at it still constitutional? And so there's this kind of a free flow. It's a living, breathing document. The law is also established and set up to have what's called precedent. And so if there is a case that says A, B, and C, and those cases continue on and people follow those cases year after year, the courts later are supposed to follow that precedent. So when the most Supreme Court nominee was being grilled by the Senate over the late summer, early fall, whenever it was, when Kavanaugh was under his hearings, they would ask specific questions. Will you follow the tenets and rulings, for example, of Roe v. Wade? And the answer was, I will follow court precedent. They always have kind of the generic amorphous answer, I will follow court precedent. Precedent means if there was a ruling, I am supposed to follow that. But as a good jurist, if they can find a way to write around and keep that precedent in kind of its own tower, but subvert and change the law, then they may go that way. And one of the more recent Supreme Court rulings that came down, I think it was last year, was that there was a cake shop owner, and he did not want to sell cakes to an LGBTA, I don't know where they were, couple that was getting married. And he said it violated his constitutional rights on freedom of religion. And so even though you would think that he or she, I think it was he, was the cake shop owner, was discriminating against the individual for their religious freedom, and that was what the challenge was going up to the court, the person said, he didn't sell me a cake because I was gay. So they were biased or prejudiced against me because of my religious choice. The cake shop owner said, yeah, but my religious choice is I don't believe in same-sex marriage. I don't believe in what they do, so I don't have to sell them a cake. And so that the Supreme Court's agreed with them. They said it's not prejudicial because it's an individual making that decision. Now, the question would have been different if it was an institution. What if there was a cake company that made a company position, or whether it was a public institution? Then you get into different questions. So that's kind of a general overview of some of the stuff of how national laws and how the Constitution impacts things that happen on a daily basis. State laws. States are each wholly separate and not obligated to follow another state's law. And what's going to happen somewhere along the line, you guys are going to be in a contract, you're going to be working on a project, you're going to be working in Illinois, and the project's going to be built in Michigan. Well, you guys got to follow Michigan laws. You got to follow what their codes and their zoning laws are, because that's what's being built. But let's say there's a dispute that goes to court. Well, if the lawsuit's filed in Illinois, Does the Illinois court have to follow what the Michigan courts say on that? That comes down to whether it's in your contract. So there's all these questions about, because each state operates separate and independently. So just because you did something in state A doesn't mean you're in state B is illegal. Like I said, medical marijuana is legal in some states but not others. The states are separate. They can do what they want. There is, though, the full faith and credit clause of the Constitution that you have to recognize the validity of another state's decision. So let's say that project that's going on in Michigan, and the lawsuit happened in Michigan, and the Michigan court decided that the architect should have been paid $100,000 for their services. But the architecture firm is located in Illinois, and the owner of the property is located in Illinois. But because the property and the project and everything else had the law and the decision was in Michigan, now property owner still hasn't paid the architect. The architect can take that Michigan court judgment and they can go to Illinois courts, and Illinois court must, under the full faith and credit clause of the U.S. Constitution, abide by the state of Michigan's ruling. So while they don't have to follow the laws necessarily, there is certain things called full faith and credit. Okay? Does that make sense, the difference between the two? Like I said, each state can make their own laws about what happens. Medical marijuana, no medical marijuana. But if there's a ruling and it applies to someone in the other state, that state has to give approval or validity to that ruling. That's the difference. Got it? Okay. Municipalities, cities, villages, they're separate and independent. They have their own rules, their own boards. It's not as much as what you're going to find in the state governments and everything else. But what also happens is they can have taxing powers. They can generate revenue, make money. So, you have your county boards, and you have to have running revenue for schools and the fire department and everything else. And so when you get out there and you have properties, the property taxes, some go to the state, but the majority of it goes to your district and how those dollars are spent out. So there's laws that are going to be in the municipal districts as well. Any questions on that? Yes?
For the state laws that are different,
Mm-hmm.
could you appeal like the Michigan ruling in Illinois?
So the question is if there's a rule, just so I understand, if there's a case that goes on in Michigan, at the state and the trial court, and the trial court says architects owed $100,000, can you take that Michigan ruling and file an appeal in the state of Illinois? Is that your question?
Yeah.
The answer is no. You have to stick to the Michigan decision tree, so you would go from trial court to appellate court to the Michigan Supremes, and whatever those ultimate rulings came in, whether you swear you stop and stuff, if you need to try to collect, or maybe you need to, so let's say that there's just this judgment in Michigan, but like I say, both entities live in Illinois, and you're not being able to collect. There's collection actions that happen. You can file your collection action in Illinois, and they would have to abide by the rule of law in Michigan. So this is a perfect example of a case that I actually worked on 2 years ago. I represented an entity that did weatherproofing and coating and sealing. They actually waterproofed the Washington Monument. Like when you walk in their office, they got this massive picture of the Washington Monument. They seal coated it. They did all the tuck pointing and seal coated it, which I thought was kind of cool. Anyway, they had a project, a big project. They did a lot of government contracts. They did a project up in Fort McCoy, which is up in Wisconsin near Madison. And they did Army barracks. And we had a judgment against the contractor my client supplied manpower and materials. And we got a $2.6 million judgment against the general contractor. We were a subcontractor. The general contractor was an Illinois company. The weatherproofing company was an Ohio company. And the facility was in Wisconsin. So we filed our lawsuit in Wisconsin in federal court. We got a judgment of $2.6 million. And they didn't appeal it, so then we had to collect. I filed a collection action. This guy's company, the contractor, was from Rockford, Illinois. I filed a collection action in Rockford. I didn't want to go up to drive to Wisconsin every time to try. Nobody's up there. But that's where the project was, so we had to have the lawsuit up there. So we would put them in collection action. Then there was a bankruptcy proceeding, and everything took place in Illinois. The attachment to my complaint in Rockford was the judgment from the federal court in Wisconsin. And under the full faith and credit course, the Rockford state court judge had to give credit to that. but the collection actually took place here. So, does that answer your question? Okay. Any other questions before we move on? Great. Okay. Then we got criminal law and civil law. Hopefully, there will be a couple little things about criminal law in here today, this semester, but basically the course is going to cover civil law. Criminal law protects the state, protects people, and we have the jury system. It's where the jury system came from. Now, my civil procedure professor, he is now actually the dean of Loyola, brilliant guy. He called it a jury of 12 cantaloupes. Because you just get a bunch of people in there. The whole jury of your peers, what's the jury of your peers? What does that really mean? I mean, you do your best to get a jury of your peers. It's a good idea, but people in the jury box may not have really a whole lot to do with you. But we have a process. We pick juries. We have it's called voir dire. And to make sure you try to get, on each side, whether it's criminal, prosecution and defense, or in civil, plaintiff and defendant, you try to get that jury to be as close to the person and personality of your side you're representing. In criminal law, there can be bench trials, but almost universally there's going to be a jury trial. It's going to be decided by individuals, 6 or 12 alternates, and so forth. Civil, there is no requirement for a jury trial. You have to request it. In fact, just yesterday, I negotiated a contract with a contractor, and they wanted me to waive my right to a jury before we actually started the project. And I'm the owner. And the reason why they wanted me to waive is because, and it made sense, it's like, Mike, construction projects, they have tens of thousands of documents. And you put those in front of a jury, and after the 50th document, not even close to the 1,000th document, their eyes are glazing over. And you lose the jury in having them understand the technicalities of the construction process. And as exciting and sexy as architecture can be, construction itself can be pretty boring. So you waive the jury trial because you don't want to have the 12 royal cantaloupes make the wrong decision. And I said to the guy on the other side of the phone, I said, I get it. I know exactly why you don't want to have a jury trial. And I'm in agreement with you. And if there's an action directly between my client, the owner, and your client, the contractor, and it just has to do with payment or defective work, and nobody's been hurt, and there's nobody outside in the universe besides our two clients that have an issue, I'm fine, no jury trial. But if it's one of your workers who slipped and fell, and the claim is that my site wasn't clean, and you say it was because we did something, I want a jury because there's a human being that's been injured. Or if there's a fraud going on, I want a jury. When we get into issues as far as that, were these people good or bad or right or wrong? A jury is good for that. Human nature, and that's one of the best parts of our system. Even though, like I say, it's my civil professor teacher referred to them as the jury of 12 royal cantaloupes, it still is one of the best things about our system, is actually being able to talk to people and trying to convince them why you're right and they're wrong, or why they were negligent or not negligent. Those are things that's really important. So, it's going to always be in criminal, not always in civil. Somebody asks you to waive it, be hesitant, but maybe you can. But you must request it. That's what in civil. The other thing is, in civil law, we're going to be balancing balancing the interest between groups and individuals. So what's that mean? So I enter into a contract. I'm an architect. I enter into a contract with an owner. Those are, under the law, treated as two individuals, even though maybe an architecture firm and it may be a corporation. Those are individuals. And those individuals have interests. The owner wants to have a really nice project. They want to spend as little money as possible. The architect wants to design it, whatever their interests are. But if there's a failure, a design failure, or if there's fraudulent actions by the owner, or something that goes wrong between those parties, those individual parties, it may affect other people. Like my example, someone getting injured on the project site is no longer in the mix of owner-architect or owner-contractor. You're bringing other people into the mix. And that's why civil law balances the interest between groups and individuals. Because a ruling on a contract between party A and party B may affect later rulings that impact the public at large. When I said earlier today about your professional practice responsibility and that your most basic requirement is to design a building that will be safe and fall down, your interest as an architect is to make money and have a profession. Your obligation to the public at large, the group, is to have a safe building. So if that building wall falls down and there's a design defect, what's the reason why? Or is it a construction defect? So the rulings of the courts, the contracts that we draft, civil law, make sure that we are taking into consideration the public as well as the individuals. What else does civil law do? It ensures predictability. We're going to talk about the AAA contracts in depth later on in the semester. Those documents are over 100 years old. They renovate them or update them every 10 years. But we want to have predictable nature. We want to be able to go in and understand what this language says. Here's what it meant 10 years ago, and here's what it's going to mean in 10 years from now. So all the parties know what they're required to do. What are their obligations? So civil law ensures predictability. We all know what's going to happen next. Civil law relies on statutes and what's called common law. Common law doesn't have any rule written down. It may be just because I had an agreement with you. It was an oral agreement. We had this understanding. I'm going to pay you X and you're going to give me Y. Common law. There's no statute that regulates what that business relationship was. There's no contract in writing other than our oral agreement. Common law tells the courts how to interpret what those agreements mean. So we have statutes and common law. Common law is just what happens over a course of time, years, decades, centuries. And then finally, again, we have the jury system, as I said, like criminal, but it's got different parameters. Sometimes you can have 6, sometimes you have 12. It's a different system than what it is. How judges bring people in, who's going to be on the jury system. Judges have a little more leeway in state court as to who's in the jury, impaneled or not. So there's a little difference, but they both use them. Any questions on this? Okay, great. Going to be on the exam. This one. So, we have a hierarchy of laws. The most important thing on the top, as we were just talking about, Constitution. We have the federal Constitution. Every state in our country has a state constitution as well. A lot of people don't know that. We all know about we the people and everything else. There's also state constitutions. The majority of the state constitutions draw directly from the U.S. Constitution. Not surprising. Because the last thing you want to do is draft a constitution that is in violation of the national law. You can't do that. But they have some little differences and nuances because, people will be caught copying, so to speak, but that's what they have. So that's the most important. Constitution, national law or state law. It overrides everything as far as how the laws are. The next in the hierarchy is a statute. Statutes, they can have federal, state, county, city. So every level of government can create a statute. That's just a law that's written down. That's what a statute is. It's in a code. It's what Congress does. But as I said, they can pass a statute. It may be challenged as being unconstitutional. So that's why the Constitution and hierarchy trumps it. Is if you have a statute and you write it and it's unconstitutional, statute gets voided. Or maybe portions of it get voided. After the statute, question, yeah. I'm sorry, I couldn't hear you. What? Are you asking, can the Constitution be changed, or what happens when it is? Okay, good question. Pardon me? The process for it to change? Oh, parameters to change the Constitution. Okay, so the way it works here in the United States is actually in the Constitution, and that's what the amendments are, or 26 amendments, okay? The first series of amendments, so we created the Constitution. And after the Constitution was written, they had the Continental Congress. They went through the Constitution, that one-page document, we've all seen it, John Hancock, big signature on the bottom, which I found out many years later, he wasn't the first person to sign. They just left him that space. I don't know why. Anyway, that's the Constitution. That's it. We the people in order to form a more perfect union, blah, 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 blah. We had the first 10 amendments. The Bill of Rights is what it's called. Those amendments changed the Constitution or clarified them. And since then, subsequent, we have 26 amendments. That's all the number of times that the U.S. Constitution has been changed, which is kind of a remarkable for a document that's almost 300 years old, that it's only been changed 26 times. The amendment process to amend the Constitution requires a vote by 2/3 of the states. The most recent challenge to create a constitutional amendment was in the 70s. And it was to create what was called the ERA, the Equal Rights Amendment. And it was based on a civil law that came into a constitutional law that's called Title IX. Have you guys heard the term Title IX? Title IX largely is spoken about. Most people know Title IX is in sports. That if you are at a university, and at a university level, now it actually applies to all educational issues and different things. But where everybody knows about it is, up and through this period of time, there would be universities that had lots of money going into men's sports, and the women's sports didn't have enough money to get uniforms. And there was actually the woman who was the grandmother of the Title IX law. She just passed away earlier this week. She was 90 years old. And they talked about the fact that like the women's basketball team had to have bake sales to pay for their uniforms. When you have these were major universities, and so she was an educator. She was trying to get money for educational, and they couldn't do it. And they wouldn't hire people. There was people that wouldn't be hired because, as smart as she was, they said, we can't hire you because you're a woman, and we only allow so many women to be hired at our university. So that was in the late 60s, and it became a movement. Title IX came in 1972, I believe it was in, and it was for any educational institution that had received governmental funding, which many private institutions do, by the way. Any governmental funding could not discriminate based on race, creed, or color. It didn't have sexual orientation in there, but that ultimately was changed. That was Title IX. They tried to take Title IX to the next level. And the movement was called the ERA, the Equal Rights Amendment. They did not get 2/3 of the states to vote. Ultimately, there's a vote that's taken in Congress. They didn't have the 2/3 state, and so it was not allowed, so the amendment failed. And so we now just have the amendments that we passed. So that's the process. So, yes, it would be a statute. Title IX is a statutory provision, but then Congress comes in and creates a request. It's a specific process to amend the Constitution. They have to call it amendment, and then it has to go through a national vote. So that's how you amend the Constitution, is through a national vote. It needs more than 2/3. Okay. So after state, that's in statute, comes executive orders. We all know what executive orders are now. We've all heard those in the news and everything else. Okay? But if you look on them, they're third. And that's why some of these executive orders have been overturned, because people say they're constitutionally not proper. And as I said, you don't need to have a Supreme Court say it's unconstitutional with the executive order. It's any federal judge that's applying the federal Constitution, the United States Constitution. Question?
Title IX is a statute.
Mm-hmm.
Can that be deemed unconstitutional?
They could challenge whether it's unconstitutional or not, yes. So any statute that's passed, any law, whether it's the U.S. Congress, the House and the Senate, that's signed by the President, that's a statute. It's just a law written down somewhere. Any statute that's written in a state, any law that's in the state, anything on the books in the state of Illinois or Texas or California, that itself is a statute. And they may be deemed state level unconstitutional in their state, or both the state laws, state statutes, and the ones that are passed by federal, any or all of them can be deemed unconstitutional in the federal level. So that's why you have, some states, you'll hear about some of the southern states or other states that they pass, I'm not trying to pick any political thing, but you hear the most in the news. Probably the most common challenge you hear on the news nowadays has to do with it's going to be either the right for abortions or what happens with women's bodies or the LGBT society. That's probably the biggest buzz in the press that we're seeing. There are other statutes that are all being challenged unconstitutional. I mean, right to search and seizure, whether can they go in and can they ask stuff. There's a Tim Cook, the president or CEO of Apple, just submitted a letter to Congress, and there was just a ruling Monday on whether police officers can require you to look at your phone to unlock it. Is your face, because there are laws out there that say constitutionally, freedom of speech, you cannot require someone to give up a passcode. If I'm a crook and I got a passcode for a secret locker or my phone or whatever else, there are already laws, U.S. laws, that have been deemed constitutional under the First Amendment that the police cannot require the criminal or alleged criminal to give up their password because that's my freedom of speech or my ability to withhold. The law came in and there were some jurisdictions, some federal jurisdictions. There's one in the DC Circuit. There's 2 or 3 levels below the Supreme Court that have now come down to say there is a difference between making the police put your face in front of your phone or not making them. They're saying that your face is not a freedom of speech. And just because you have elected to buy a phone that uses a digital process by which to create a password, you cannot protect that. Some judges say police can make you do that. Some judges have said no. So that's an open question. The most recent question, though, the way they challenged it, and the judge I think it was a California judge, favored the individual making the challenge, saying the police cannot force them to put the phone was they said they challenged it not on freedom of speech, because the judge said, well, your face isn't freedom of speech. Everybody sees your face. It is what it is. They challenged it on the right to self-incrimination. So the Fourth Amendment, or the Fifth Amendment. You hear about somebody taking the Fifth Amendment. I choose not to answer the question on the ground it may incriminate me. That's the Fifth Amendment. That's part of our U.S. Constitution. You are not required to testify against yourself in court. This California judge said, if the police can force you to put your phone and open your phone, of the hundreds of thousands of things that we all carry on our phone, if you ever sat down and thought about every picture, everything, and if you're a crook, is forcing someone to open their phone self-incrimination? Because now the treasure troves that you decided you wanted to keep protected is open. And on that basis, the court said, no, the police cannot require you to put your face and to open your phone and unlock it. What the challenge is going to be on that is, the Fifth Amendment applies to testifying in court. Does this application of being questioned at a police station, is that the same as testifying in court? I don't know. But that's where the whole state law, those are state laws, but they're being challenged as whether they're constitutional. So it could be a state law, it could be a federal law, all go up because statutes are below Constitution. Executive order is below statute. And that's why when I was talking about when the executive order on the travel ban was stricken by a federal judge I think in Washington State was the first one, and there was Hawaii, some other ones, why they applied it across the whole country is because they're taking this executive order, they're applying against the national law and the Constitution, it trumps everything, and so we are going to apply it, and I can't just apply it only in the state of Washington, I'm going to apply it across the country. Governors can also have executive orders, so it's not just federal, it's not just the president, but governors also. Can mayors do it? I don't know. Richie Daley probably did a lot of them. Who knows? I don't know if Rahm's done them, but it's in that. I don't know if they technically have the power. I haven't looked in the City of Chicago code whether the mayor of Chicago can issue an executive order. But I do know that they in the hierarchy they exist on at least the federal state level. Underneath that, the next one down, administrative order. So it's part legislative and it's part executive. So you guys are governed. When you get out and start practicing, you're going to be governed by what's called the Illinois Department of Professional Regulations. And that governs doctors and lawyers and all professionals. That is a governmental agency that's created under the state of Illinois, and every state has their own form of it, that's going to govern your conduct, both professional and business. And there will be laws or codes written down. And if you violate that, it may not be a violation of a criminal law. It may not be a violation of a statute, but you may violate something that an administrative body has control over, and they will issue an administrative order against you. That has effective law that then someone can take that law and then go to a court and say, they violated this, we need this enforced. That's fourth on your level of hierarchy. Below that, common law. Common law is, like I said, it's court-made law. There's no statute. There's no contract. It's the court's, well, maybe sometimes based on contracts, but it's the court's rulings. So when we talk about things like Roe v. Wade or any of these other Marbury v. Madison, some of these huge cases that come down, or even the one that allowed, what's it called? The one that allowed the super PACs. United Citizens, or Citizens United. That is the text of that decision, the written word of that decision, is the interpretation by the court of a statute or the Constitution or other elements, but the text of that case alone can be used for arguments in future cases. And then from there and there and there. And that is how common law is created. So the first case may have been based on a statute or may have been based on an administrative order, but the court law, as it goes over the years, decades, centuries, becomes common law. The bulk of our law is common law. There can't be that many statutes, but there are millions of cases out there. And that's what I do. When somebody comes to me and there's a dispute, I go online, I go to Westlaw or Lexis, the two legal services, and I look for case law to support my argument. When I get in front of a judge, I argue the cases. This case had these set of facts, Your Honor. They're really close to the set of facts in front of you today. This court decided X by common law, stare decisis, precedent. You must decide X as well. So this is where the wheelhouse of my world is. We start up here, but this is what happens in most of that, in the hierarchy. Next down from that, contracts and agreements. So there may be a statute out there, or there may be silent. There may be an administrative order, may be silent. There may be common law out there, may be silent. You can enter into an agreement with anybody to do anything. And that's what the contract is. I agree to pay you $5. You're going to give me your brand new Ferrari. We can enter into that agreement. Now, is that a valid agreement? I don't know. Why would I make that agreement? What are the understandings? What goes in? And how those things are interpreted, the courts will go upstream. Did something part of that, was that transaction between the parties unconstitutional? Was that transaction in violation of a statute? If I was a minor, I would be in violation because the minor can't enter into business transactions and can't do that sale. So that would be a contract, but it would be a void contract because it was in violation of the statute because of the hierarchy. So parties can agree to do whatever they want, and those are enforceable unless they're in violation of the other five right above it. That's the hierarchy, is how it goes with contracts. And then finally, just the custom and practice. We all are out in the industry. We all know that when an architect's on site, they're going to walk around the site, and they're going to see how the construction goes, and everybody kind of knows generally what your job is. And when the contractor's out there and he's building the project, and he's swinging a hammer and nail, and he's got his tools and everything else, generally the industry knows what they're going to be doing. The reason why this is important, this custom and practice, is because if you think about it, so you're building a 50-story high-rise. And you're going to do the drawings, but you guys are not going to draw every single window and every single door and every single threshold and every single bolt connection because your drawings would be as big as a building. You're going to have a typical one, and that's how they're going to build it. And they all know this is how I do a weld. This is how I install a window. This is how I do course runs on my brick course. This is how I do a weep hole. Everybody has an understanding of that. So your contract doesn't have everything in it. Your drawings don't have everything in it because industry custom and practice allow the parties to kind of know what they're supposed to do. And unless of course, what they did and they thought they were supposed to do violates what the contract said, or what they did and they thought they did violates common law or going up the stream. Does that make sense? All right. Any other questions on this? Okay. That's the basis of the kind of the history of the law and everything else. Now I'm going to give you a little bit of examples about claims. So when we have contracts, we have parties that get into agreements, everybody's working along, but sometimes there are disputes. There's a disagreement between the parties. That's what's called a claim. Okay? So, what are claims? Well, we have claims, that's why we need the laws. Because if people disagree, we have to have some basis to go figure out what's the resolution. Sometimes it's who's right and who's wrong. That kind of is probably more on the criminal side. But sometimes it's in the civil. But at the very least, what's the resolution? How do we resolve this dispute, or how do we come to an answer of who should prevail on the claim? You hired me to design your building. I told you it would cost you $100,000 for my drawings over the next 6 months. You've paid me $40,000. You owe me $60,000. My claim is you owe me the money. You say, I don't owe you anything because the drawings you gave me were crap. You're late. You told me you get them in 6 months. It's been 12 months. I'm losing money out of pocket because my project was supposed to be up and running. You haven't earned your $100,000. What I paid you was too much. That's a dispute. So we need laws to figure out. Is my argument, I did everything and you owe me $100,000, is that the right argument? Does that prevail? Or is their argument, well, you're late and your drawings are crap and I'm losing money because of your failures, does that prevail? The law tells you how to answer those questions. So, we obviously have civil and criminal laws. Sometimes there's criminal statutes that you violate. Sometimes people commit fraud. There's criminal fraud. There's civil fraud. There's all different kinds. So, sometimes you'll have criminal issues come into construction projects, people that are taking money on the take, payments under the table, much more in governmental issues. I've had a couple of projects that have had some criminal issues involved. In fact, I had a lawsuit that was pending over in the western side of the state, and the main party didn't pay us, and there was a building that was constructed, and it turned out later on that another building, a different building, but at the same period of time, they had paid off bank officials, allegedly, because the criminal trial isn't over yet, it's still pending. But they allegedly came in and paid off bank officials for a loan, and some of the funds, allegedly, that was owed to my client by this individual went into the down payment for this building, of which there was the bank fraud going on in the loans. And so in the middle of my case, and I had a very aggressive opposing counsel, and was not giving me an inch on my case, even though I felt we had the better case on the law, the facts of our case. In the middle of that case, his client was federally indicted, and as we kind of unraveled that for bank fraud, as we unraveled those questions, it turned out that allegedly some of the funds that were going to be connected to my case were potentially tied into this federal criminal action. We ended up getting a lot better result in that case as you can imagine. So I've had some criminal issues. Okay, most of what we're going to do is we're going to cover civil claims. Claims against design professionals, which you guys will be later on. Although you guys are all design professionals now as far as I'm concerned. Claims against owners, claims against contractors. How do we understand those? That's what we're going to talk largely about, how do they resolve them? How do we resolve if we have this dispute between design professionals, owners, or contractors? Well, there's two ways to do that. There's two types of what we want to resolve. There's two types. One is there's what's called a tort or a contract case. Those are two types of claims, and how do we resolve that? The first one, tort. A tort is an injury. Now, it could be a physical injury to your body, or it could be an injury, quote-unquote, injury to property. Trespass is a tort. Fraud is a tort. So there are types of things, but it's principally, when you're going to hear it, the most common tort, and that we'll use for almost all of the examples throughout the semester, is someone that's injured. So you can have a tort because you slipped and fall. You can have a tort because someone, they did the surgery on the wrong knee. You can have a tort because a wall fell on somebody at a construction project. Anytime that there's an injury, you're going to find a tort. You could have a tort where the wall fell over and it knocked down the other person's property. Or as you're digging the foundation for the project that you're working on, that causes differential settlement to the next door neighbor's property and cracking. The lawsuit by the neighbor's property whose foundation is now cracking will be brought in tort, not in contract. Contract. What's a contract? Well, a contract is an agreement between two parties, two or more parties. It's defined to the individuals or entities that are part of that contract. So, I'm an owner. I hire you as an architect. If we have a dispute between what we did and what happened, that will be a claim brought in contract. If someone is injured on our project and the injured party sues me, the injured party will sue me in tort. If I feel the reason why this party was injured is because you had a bad design, the third party, the person that was injured, could sue you in tort as the architect, could sue me in tort, or just sue me in tort. So they're just going to sue me, that's in tort, because I don't have a contract with that injured person. But if I'm the owner, and I say, you did a bad design, architect, I'm going to sue you in contract, even though I'm being sued in tort. Does that make sense? Because I have a contract with you. So the injury and the basis of the claim is going to generally be in tort, but if you have a relationship in contract, whether it's oral or written, you're going to have a basis of agreement, a claim in contract. Okay? And so lawsuits can have both. My example just now was a woman was injured on our project site. She sues me in tort, says it's because of the design of the building, the wall fell down on her. I go ahead and sue the architect, said you were supposed to be responsible for design. My contract is you said you were going to build me a safe building. You didn't, so you breached your contract. Same lawsuit, same claim, same injury, same set of facts, but we have a tort claim and a contract claim. Okay. All right. What makes up a contract? Like I said, it's an agreement between two or more parties to do services or to do something, and in return, there has to be an exchange. I'm going to do something for you, in exchange you do something for me. The most traditional is, I'm going to pay you, and for payment you're going to give me something back. But you could have, I'm going to give you something, and you're going to give me something back. It could be, I'm going to give something over here, and you're going to give me something back, because the agreement is, I don't want anything, you're going to help a third party. So, but it's always going to be an exchange of something to create between the parties an agreement of one or more parties. So that's what a contract is. Any question on the difference between a tort and contract? Did you have a question?
Yeah. So when does a contract become a contract? Is it doing when the ink is dry or when it's finally?
Excellent question. So the question is, when does a contract become a contract? And I don't know if it's next lecture. Let me see my little notes here. Next lecture I'm going to talk about a lot more, but I'll ask you anyway because you're right on top. A contract becomes a contract, as basic as it is, when the parties come to an agreement. It doesn't have to be signed. It doesn't have to be oral. It's when you know that there is an agreement, a mutual agreement between the parties, and that sometimes is the litigation. I thought you said this. No, I really said that. Well, I heard you say that, but I thought you meant this. Is that an agreement between the parties? I don't know. Maybe the courts and the jury have to decide whether the parties came to an agreement. So the contract becomes valid when there's an agreement. It doesn't need to be in writing. There's some other nuances we're going to talk about next week as far as like, what happens if I send you my offer? I will design this building for you for $50,000. Here's my proposal. I'm going to send it in the mail. I receive that proposal. I'm like, ooh, that's a good price. And I sign and I stick it in the mailbox that says, I agree to your proposal and I stick it in the mailbox and I accept we've come to an agreement. Now, takes Chicago Mail 3, 5, 7, 8 days to finally get there when it actually is delivered, my signing and say I accept your proposal. And you call me up and say, oh, I did the calculations wrong, $60,000. And that comes to me before you've received my thing in the mail. But after I've signed it. What's the agreement? What do you think? 50 or 60? Who says 50? Who says 60? 50's right. That's called the mailbox rule. Once you stick it in the mailbox, that acceptance is valid. But there's all these other, but a rejection may not. If I reject that claim, that rejection isn't valid until you get there. We'll talk about that next week. There'll be a couple questions in the exam of that. But that's a good question. You just need to have an agreement between the parties. But then there's all these little scenarios that come up. Well, I don't know if it was an agreement. I don't know when, where. But we'll figure that out as we go through the semester. Okay. So, claim. So you have to have a claim. 2 types. Tort or contract, principally. Next. In order to be a claim, you have to have a duty. So you got a claim. You have the existence of claim, you have to have a duty. Everybody has to have a duty. I will pay you this. That's my duty. You will provide me drawings. That's your duty. The obligations to each other. If you don't have that, there's no claim. You call me up and say, hey, I heard you're doing designs. I know you're going to be building a house. Let me send you some drawings. I really want your business. I think that would be really cool. So you send me some drawings for a new house because we're friends. We get them. I'm like, oh, this is kind of nice. Yeah, I'm interested. And you go somewhere else. I go like, I think it's really kind of cool, but not completely our style. And you hire another architect. You can't call me up and say, I owe you for those drawings. You spent $10,000 on preparing them and sending them to me because I had no duty to pay you. I don't have an agreement. You sent those to me unsolicited. So you didn't have a duty to me, nor I had a duty to you. So you have no claim for the cost that you incurred to prepare those. Pretty simple. That's a duty. Continue on. How do you get a claim? If there's a breach of duty, that's the dispute. You didn't pay me. You told me you paid me $100,000. You've only paid me $40,000. You owe me $60,000. You have not fulfilled your duties, your obligations. You have therefore breached your duty. Now, I'm giving you these examples in contract. I agree a contract with you to provide you drawings. I'm going to pay you. You're going to provide me drawings. That's a contract relationship. How does this work in tort? What's the duty in tort? What's the breach of the duty in tort? And this goes back to your professional responsibility. As a design professional, your duty is to design something safe and that works. Your duty to the public at large. It's not a contractual duty. It's a societal duty. As a homeowner, do you have a duty, or let me take it a different question, not as a homeowner. As a shop owner, do you have a duty to shovel the snow and ice in front of your front door? You do not, actually. You don't have a duty to shovel. If you do shovel, you have a duty to make it safe. But if you ignore shoveling, that's Mother Nature. And if somebody slips and falls on your snow and you didn't shovel, you aren't necessarily liable. If you tried to shovel and somebody fell, and as a result of your shoveling, you were negligent in your shoveling and someone slipped and fell, you may have breached the duty to create a safe space. That's how tort works. So you have a duty. Do you have a duty to shovel or not? Maybe, maybe not. If you did shovel, did you breach your duty? And there's all different things in that on societal duties. And some societal duties have been codified. So, like the American Disabilities Act. We really should have a duty to make sure that people that have disabilities have full access to the buildings and spaces and everything else. And up until the 80s, there wasn't any statutory requirements to that, but they came in with the American Disabilities Act. And they said, now you have a duty. You have to have so many rooms in a hotel that are handicap accessible or ADA accessible. You have to have rampways. You have to have there's all these things that are now codified, and now they're statutes. So, sometimes you have a duty that's common law that becomes a statute. That was something that, but neither of those, if you fail, like if I am, and I've had many of these lawsuits. Actually, we were in the process of dealing one. We represented for a brief period of time, the Los Angeles Rams and their new stadium out there had countless ADA violations. Those claims were all brought because the public at large don't have a contract with the 49ers. Maybe some season ticket holders did. Those claims of violation of the ADA Act were effectively torts. They have a statute that says you violated the statute, but it's a tort. You haven't designed a space that's accessible to people with handicaps and disabilities. Okay? So, tort contract, duty, and if you breach your duty. Two other elements. Cause. Was the injury that you suffered caused by the breach of duty? The question comes in. Did you shovel? I shoveled. Did you shovel properly? Yes. Did they slip on the ice? No. Would they slip on? Maybe somebody left a roller skate in front. I don't know. But it wasn't the cause of the injury. So in that. So you have to go in. Causation is an important element. And that's the connection. That's the nexus. Was the party negligent? The wall fell over. Was it a design error or a construction error? Or was there something that happened during construction? Was there wind forces? Were there things that came in? Was there acts of God? Did the injury that was suffered, was it caused by the breach of duty? And sometimes, interestingly enough, you can breach a duty, but that breach wasn't the cause of the injury, it was something else. So you could have a building that maybe you didn't design it properly, structurally it wasn't sound, and that there was a vandalism or lightning struck or something that was out of the control of anybody else and a raging fire happened. And the wall that you didn't design properly fell over and hurt someone. And then the question in the litigation is, was it the failure to design this wall properly that caused it, or was it that caused the wall to fall over? The failure of the wall. Was it in your improper design that resulted in the wall falling over? Or was it the high intensity of the heat that melted the bolts or caused the connections to have a stress failure? Which was the cause of the injury? So sometimes you can breach your duty, and it's not the cause of the injury. So that's a question that sometimes is litigated. This is what experts are about. Causation is experts. And then finally, damages. If you don't have damages, there's no lawsuit. If you never really cost anything, it didn't cause you anything, there's no lawsuit. Okay? So, you have all these elements, whether it's a tort or contract, claim, duty, breach of duty, causation, and damages. If you have all five of those elements, how do we solve them? Well, there's the old school. You go beat somebody up, get the money out of them, tough guy in the block. Or there's a law, legal methods. That's what I come in for. And there's two ways you can do that. The dispute resolution procedures. There's what's called, we have binding and non-binding dispute resolutions. Now in construction, the reason why I bring this up this way is non-binding is really important in the construction world. Almost every case that I deal with, we mediate first. Mediation is a non-binding resolution where you have a third party come in and he or she listens to both sides of the story and says, they are hopefully an educated third party, they say to the two entities or three or however many that have a dispute, I've listened to all your stories. I've seen all your facts. And if this went to court, this is what I believe would happen. So let's try to work this together and have a business resolution. And at the end of that day of mediation or days of mediation, whatever it is, because I'm just a third party, I'm not a judge, I'm not an arbiter, I can't force you to do anything. So whatever I say isn't binding, but it's a recommendation to try to get business resolution. And it's about negotiation. So that's what's on the non-binding side. Binding side is the lawsuits or an arbitration. Litigation, it's expensive and time-consuming on the binding side. Arbitration, you have to have an agreement in your contract. You can't just say, let's always arbitrate. You have to have an agreement. It can be cheaper. It can be faster litigation. The debate is out on that, whether it is or not. But those are the two binding. Both of these, if you get a decision, both of these are asking for a decision. One is the courts give you a decision. One is an arbitration panel to give decisions. So that's why they're binding and they are enforceable in law. Mediation and negotiation on the non-binding side to resolve your claims, your dispute. As I said, neither one binding. Any questions on that? Okay. So now let's I'm just going to briefly go through what happens if you're in a lawsuit. That's one of the claims, one of the ways to resolve it. So these are the steps that you're going to have if you have a lawsuit. So we have a contract between the parties, or there's a tort. We go in, somebody's injured, somebody has damages, they file a claim in court, file a lawsuit. What do we do? So the first thing you're going to have, and these are civil, by the way, you're going to have the plaintiff. The plaintiff is the injured party. If we were in arbitration, they call the claimant. That's the plaintiff. And they file a summons and complaint. First, they hire an attorney. You may be a pro se, being by yourself, but only if you're an individual. Companies can't be represented by themselves. They have to hire a lawyer. You file what's called an appearance. The lawyer appears, files a piece of paper, it's called an appearance, and says, I'm appearing on behalf of Company X, or I'm appearing on behalf of individual Y. I am their voice, I am their representative in court. That's what the lawyer does. And then we go through the process of what it is. So that's what the first step is. The plaintiff files a summons and a complaint. The complaint alleges the facts of everything. The summons is how you're served. You've been served. Here's your complaint. Yes. Okay. The defendant gets it. The defendant's the other side of the case. One that they're saying, hey, you did something wrong. Sometimes you may sue me and then I may sue you. I countersue you. So I become a counterplaintiff, you become a counter-defendant. But we won't get into that too much. So the defendant, the first thing I'm going to do is I'm going to file my appearance as well. I got to get a lawyer. They're going to appear on behalf. So both parties have a lawyer as their representative in court. And I may file what's called a motion to dismiss. I've read your complaint. And it's against Michael S. Hanahan. I'm Michael J. Hanahan. You got the wrong person. I'm going to file a motion to dismiss. True story. Some guy from the South Side, his name's Michael S. Hanahan, had some financial issues. I was in law school. I got sued. Got out of it. Wasn't me. I don't know who he was. I've never met him, but wrong guy. So that's a motion to dismiss. It's not the right person, not the right case, not the right law, whatever it is, you move to dismiss, goes away. Or, yeah, you got the right person, but I don't agree with your allegations, so I'm going to answer your complaint. Deny, 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 deny. Oh, you got my name right. Agreed. Deny, 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 deny. That's what the answer looks like. Affirmative defenses. Yeah, you got me right. All the facts are the wrong person, but I don't owe you any money because you never gave me what you told me you were going to give me. That's my affirmative defense. I'm going to come right out of the box and tell you. You had a duty and obligation yourself. You failed to perform that. So my defense to your claim that I owe you money is, you never delivered to me. So, you can file an affirmative defense. And not only did you not deliver to me, but you cost me money. So I have a counterclaim against you. So that's what the defendant's going to do. Complaint by the plaintiff, answers, appearance, defense by the reactions by the defendants. Now we're all at what's called at issue. The complaint's been answered. We're in front of the judge. How do we figure out the facts of the case? This is all what's going on, like I was talking about the subpoena. It's all the pre-trial discovery. So the purpose is to exchange information, the flow of information. So we have this decision presented to a judge or jury where all the facts are put out, so whoever's making the decision can make the best decision on the most amount of facts presented, of course, in the light, the way one party wants to present their facts and the way the other party presents their facts. So we have the production of documents. We have production of interrogatories. Interrogatories are written questions. We've all heard about interrogatories lately. Depositions. Depositions are oral questions, but it's again exchange for information. Depositions are restricted at lots of places on time and location, who can be deposed, lots of things that come into that. Third parties can get a subpoena. A subpoena is a court document that says, I know you and you and you are in a lawsuit, but you three people over here have not been sued, but you have important information. One of the entities in the lawsuit wants your information. I, as the court, am going to mandate that you give the information to that. That's what's going on right now with the secret company in front of the Supreme Court. Mueller's investigation team has subpoenaed documents from this entity. The entity says, I'm a foreign company. I don't need to abide by the U.S. laws. That's their basis argument, which has been denied in both courts. And that will ultimately be in front of the Supremes, but that question hasn't been presented. So their refusal to abide by the subpoena, Mueller subpoenaed their documents. And that's the power. Subpoenaed the third powers. And the question will be ultimately answered is whether they as a foreign entity are obligated to provide documents in response to the subpoena. Third part, the length of time. This is the most lengthy part of the lawsuit. So if you're in Cook County, you file a lawsuit over in Daly Center, construction claim. From the day you file till the day you go to trial, 4 years, maybe 3. And the bulk of that period of time, at least 2, maybe 2.5 years, is this part right here. Exchange of documentation, depositions, the pre-trial discovery, how we learn about stuff. This is what takes the most time. And this is what's called motion practice. Motion practice is like, you want these documents, I don't want to give them to you, they're privileged, all right? Well, I'm going to file a motion to compel. Or, you gave me some documents, I know there's more, I'm going to file a different type of motion. So there's all these legal battles. As I gave this example of this company that's in front of the Supreme Court, the first one was, do I have to pay this $50,000 a day fine? That was a motion to bar the requirement for them to pay. The Supreme Court said, we're not going to hear that motion, it's not constitutional, so the fine stayed. Now they have a second motion. Are we allowed to file briefs under seal? Neither of those get to the real issue as whether a foreign corporation needs to respond to a subpoena. That's the motion practice that's happening right now. Okay? Trial. Jury or bench. Bench trial is if you have a judge. Jury is the cantaloupes that we talked about. You have jury selection, voir dire. You go through, you have a whole bunch of people, and you ask them questions, and you bring them on. They become your way of determining whether they're the jury of your clients, respective clients' peers. Sometimes the judge handles the voir dire. Sometimes the judge allows the litigants to do it. It all depends on what court you're in. Then you're at trial. You have the opening statement. Now, there's the opening statement and the closing argument. There's a little distinction between those two. When I'm up in front of a judge or jury at the beginning of the trial, I'm going to say, the evidence will show, you will hear this. This is what the case is about. I am not allowed to say, he didn't do it. I'm not allowed to make an argument. I'm going to make a statement factually. Now, depending on what judge you're in front of, depending on what the case is about, sometimes, and depending how good of an orator you are, sometimes your factual statements will blend and bleed into argument, and the other side can argue and object and say argumentative. So, but it's an opening statement. The closing argument, you're going to say, ladies and gentlemen, you heard Mr. Hanahan say you were going to see facts about A, B, and C. I didn't hear any of those facts. And you know why? Because his client didn't do it, or did it. And if they had the facts, you would have seen it. I'm making complete argument. I'm making an argument. He promised you something that never came. Or, you heard that witness on the stand. Could you really believe that? I know he said it was true. I know he was under oath. I didn't believe it. That's all argument. So, the drama that you see on the TV shows about the arguments and the passion and the pathos that comes into it, that's mostly closing arguments. You're going to see TV shows also where they do opening arguments, which should be opening statements, but that's what happens there. Evidence and witness, you're going to put witnesses on the stand, you're going to ask them questions, that's your evidence, and submitting that. There are specific rules about how evidence goes in. I'm not going to bore you with that. Certainly not going to bore you with jury instructions, but there are specific statements that the jury, you give, and there's battles, there's fights between the litigants about what the jury instructions should say. You know, if you find this, you must find that. You give them sets of rules so the jury doesn't get back in the jury room and kind of, the Wild West. And then obviously there's a judgment or verdict ultimately comes in on the case. Last step in it is an appeal. Well, let's say you didn't like that judgment or verdict. You're going to appeal it. You're going to have written on specific limited issues. You can't just say, I didn't like the whole thing. You have to find where the elements that came in. The jury decided this. This is against the manifest weight of the evidence. I'm going to bring an appeal against this. Or the jury found that. This is against a statute. Even though the jury, common law, made this decision, it still violates the statute and you take it up on appeal. So you're looking to the next higher court to hopefully be a check and balance on what the cantaloupes may or may not have done. Sometimes you get oral arguments. In the 1st District, which is where Cook County is in the northern part of Illinois, about 3% of all cases that go to the appellate court in the 1st District get oral arguments. The other 97% don't. I'm lucky enough that I had one oral argument. It was really scary. You get up there's these 3 judges. Their bench is about 8 or 9 feet above you, so you're just doing this. You look it up. Every judge is going to be raised above you, by the way. Just anytime, any courtroom you're in, the judge always sits up above. But this was the highest I've ever seen in these 3 judges. They're all really smart, and you step up and you start to make your argument, and they just pepper you with questions. It's like, what about this? What about this? What about this? And you're like, it was really intense. Luckily, I had a seasoned veteran sitting next to me. She knew more about this stuff than anything else. She had prepped me really well. I was younger in my career. It was probably 15 years ago, 20 years ago. She had really prepped me well. And at one point, though, thank God, because I was getting shelled, she stood up and she's like, "Your Honors, may I?" And she stepped in and kind of got us back on track. And we ended up winning, which was kind of cool. So I have my name in a reported case of an appellate case. So that was really kind of a fun one for me. But that's what happens, oral arguments, maybe. Yes?
If you're settling, can you settle with someone at any time?
You can settle whenever you want. I'll tell you where most of the settlements happen. Settlement happens like a half an inch above this number 4. You get all the way to the courthouse steps. I don't know how many cases I've settled within a week of trial. Or within 2 weeks of trial. And normally what ends up happening, in fact, I had a case that settled in October that we were a week out of trial, and we'd had 2 mediations. They were completely worthless. They went nowhere. Everybody was intracted. They just would not move and not budge. I think the mediator wasn't very good, but that's my own humble opinion. We got a new mediator in, and 11 hours, and we hammered that out. We settled it because what ends up happening is people recognize if you get past that half an inch above number 4, the cost and the risk of that. This was going to be a 2-week trial, and it was probably going to cost my client about $400,000, and then the judgment could have been anywhere between $0 and $1.5 million. And so they're like, okay, we're going to spend $400,000. We could get tagged for $1.5 million. It's not that we don't think you're really good, Mike, but if we get out for this for less than $400,000, but we just to try it, let's do it. And we did. So sometimes, and I've settled so many cases in my career. I tried a couple cases. I tried a half a dozen cases, which is a lot for a lot of people. There's true trial lawyers. Most litigators don't try cases. Most of them sell cases. But I've tried a half a dozen of them. Most of them I settle, and never once have I been like, well, you settled because you didn't think you couldn't have won. It's you settled because it was a business decision. So that's my job. Is at the end of the day, it's as much as recognized, as much as I think we can win, as much as their case sucks. It's still their business. It's still their money. It's their life, and we help them out on that. So, okay. So if you don't go to court and trial, you do arbitration. Arbitration is something by agreement between the parties. So in your contract, there has to be a provision. It has to be in writing. So like if I had an oral agreement with you, and you're going to design me drawings, and I'm going to pay you, and that was all it was, we're not going to arbitration because we didn't have an agreement on that. We could agree later on between us, but if you said, I want to arbitrate, and I'm like, no, I don't want to, you can't force me. So you have to have it in writing. Arbitration needs to be in writing, but it's a different form. It's a different format. No jury. And the rules of evidence are a lot looser. There's going to be a panel. Am I getting ahead of myself? Well, let's go start here. So you have a demand for arbitration instead of a complaint, by a claimant instead of a plaintiff. Same person, though, same entity. It's in writing, but it could just say, I did some designs for them, they didn't pay me. Whereas the complainant says, I'm this company, I'm from this city, they're this company, they're from this city. Our contract said this, we did this, these are the people involved. It gets very formal in a complaint. Arbitration demand can be very informal. Most of the time it's a little more detailed than that, but it doesn't have any requirements. You have an arbitration selection process. You got to pick who's going to be the arbiter. Sometimes that's in your contract. Sometimes you have to talk about it. You define who's going to be. Sometimes you can have one arbiter. Sometimes you have 3. Sometimes I pick one, you pick one, they pick the third. All these kind of rules that are out there and get an arbitration panel. But normally it's 1 or 3 people on the panel. What I recommend to all my design professional clients get at least one architect on the panel or a lawyer that represents architects, so they are biased towards you. It's different than a judge or a jury. You can get the jury of your peers, but you may not be able to control the biases. But if you're an architect and you get a panel of our architects, you know they're biased towards your thought process. So that's one thing. It's a nuance, and that's what you try to get. There's an answering statement in counter demand that's kind of like the answer, but you don't do the motion practice, and you don't because you already have an agreement. It's not like they got the wrong person or the wrong project. They're not going to be motion to dismiss. So you just do an answering statement. Yeah, I know they said I owe them money, but I don't. Here's the reasons why. Again, they're quite informal. It can be formal, but it doesn't need to be. Limited discovery. They don't like the years and years and exchanging and everything else. Problem is lawyers are so entrenched in the way they do stuff that they've turned arbitration into just a different type of litigation. So you can still have an arbitration that goes 4 years, and you still have the costs and the depositions and the exchange of documents. It's not quite as expansive, but you still go through all of those things. There are some rules on how you do a mutual exchange, depending on if you're using, like if you have the federal arbitration rules or the AIA has rules, various rules that are out there. Very limited interrogatories, but sometimes you can ask the panel, can I serve interrogatories? Again, depositions. So what I do when I write a contract is I say, you're allowed to have 4 depositions for 3 hours each. That's it for the whole case. I don't care if it's a multi-million-dollar case or a $50,000 dispute. 4 deps. Pick your 4 people. If it's to my client's benefit to have more than 4, then I'll let them have more than 4. But that's what I try to do. So it's to keep the costs down. Again, it's defined in the contract. Limited control over discovery period. You can have subpoena power, like when I was giving the example, to get that third party to come in. But the power is significantly less as far as what they can do. But you can enforce someone to come to an arbitration hearing if they're in the jurisdiction and some other stuff. So in some ways it's a trial light, less. And the purpose of arbitration when it was really started to become developed, which was in the 60s and 70s, was to bring down the court cost and shorten the time from claim to dispute. To take that 2 to 4 year lawsuit window and bring it down to 6 months to a year. In my opinion, it's not that anymore. And in fact, the most recent round of AIA documents have gone away from arbitration as mandatory. But it's a dispute resolution process that you can use. There are reasons why you might want to, though. Like I normally like litigation, but there are some reasons why you might want to do arbitration. Let's say your client has private issues. Like I represent a lot of high net worth private people. They don't want to be in court. They don't want anybody seeing their public records. So we'll do arbitration for that. You're going to have an evidentiary hearing in front of a panel, so it's not like in trial in court. The rules of evidence are a lot looser of how documents go in. There's not the distinction between opening argument and opening statement or closing argument and closing. There's not those distinctions. So while I say it as opening statement, you can be argumentative in that in front of a panel. There can be witnesses. Sometimes the panels will say, I just want the witnesses' statements in writing instead of seeing them live. The arbiters will ask questions. Even though they're ones making the decisions, they're going to interrupt you and ask questions. Closing arguments and briefs, and then they're going to issue an award. So it'll be like a judgment, it'll be an award. I have read the contracts, I've heard all the evidence. The award is one party gets this money, the other party does not. And that award can be enforced. The biggest difference between arbitration nowadays, years ago it used to be time and money, but the biggest difference nowadays is there is no right of appeal. So if the arbiter screwed up, tough. I had a $600,000 arbitration award against my client. It was so wrong. So against the manifest weight of the cases. Just clearly wrong. That's why I don't do arbitration anymore, because we were stuck with it. Can't appeal it. I mean, it was terrible. Now, you have a little bit. If you can show that there's fraud or bias, overt bias. The arbiter on the panel forgot to tell me that his sister works for the company on the other side. oops, there's a little bit of bias there. Or the arbiter has committed fraud or had some other issues as far as the communication. So you can appeal on that. The arbiter didn't have jurisdiction. Maybe they weren't allowed to be working in that area. Maybe they weren't a licensed attorney. They didn't have jurisdiction in the area. So that's one way out. Or if it's such a reckless disregard, which I thought mine was in my case, but it wasn't enough for appeal. Any questions on arbitrations? All right, last thing up, mediation, and then we're out of here. Mediation was what we would have in the beginning. It's the non-binding process. Remember that chart way back when? It was on the right side of that little box. Non-binding. Some mediators are combined with arbitration. They call it meet-arb to have a binding thing. So what happens is the parties go and they meet. They tell the mediator stuff. And if they can't come to a decision, you just continue going on with the same individual and they come up with an arbitration. But most of the time it's just the individual's mediation instead of meet-arb. Two types of mediation. Evaluative and facilitative. The evaluative is they come back and they evaluate the basis and merits of the case, and they actually, at the end of the day, have a written statement that says, I've listened to your facts, I've listened to what your case is, and I believe this is the answer. So it's like opinion that a judge is going to give you, but it's not binding. But at least it's an evaluation. They use case law. They tell you where the court's probably going to come down with it. That's evaluative. Facilitative, they do, I say here does not evaluate the claim. They do a little bit, but what happens is they get everybody in a room, and this is the majority. I'd say about 75% of mediations are facilitative. Evaluative is here. The better mediations are evaluated. The bigger mediations where there's higher stakes, and the more sophisticated mediators are in the evaluative because you ask them to listen and write an opinion. Lots of people are out there that are mediators that just say they can solve problems. A facilitative mediation is, I hear your arguments and I hear your arguments. We get in a room, and you guys get about an hour to yell at each other and say whatever you want back and forth. However you want to present the case. And I'm going to sit back here, and then I'm going to put you in a room, and I'm going to put you in a room. And we're going to go back and forth, and I'm going to facilitate a discussion. And I'm going to talk more about what the economics and the reality of the case is, the necessary evaluating the legal merits. I'll throw some of those things in as a facilitative mediator, but my job is to get the parties talking and money flowing. That's how we settled that case in October. We had a really good mediator. He gave us an evaluation, but then he came in and he said, you guys aren't going anywhere. And then he created this and it was the first time I ever had it, was this unique high-low process that he said to me, he's like, Mike, give me your highest number and your lowest number of what you think you could settle for. I said, well, we're not going to pay over $500,000. I don't know I think that was our number, maybe 400. Our low number, what we're going to start out with was $100K. He's like, okay, your window's 1 to 4. Went to the other side. What's your number? Well, our high number is 1.5. Our low number is $1 million. So he's okay. So they came back and he said, so you're not at 100 and 1.5. You're not that far apart. You're at 400 and $1 million. So by a process that had nothing to do with the merits of the case, he created a smaller gap. Now we're at $600,000, and we then shifted the brackets. And the brackets started sliding, and we ended up in our bracket, which was good. But that was a facilitative process, as opposed to him saying, your case means this, and this is why you're going to pay that. So that's just the difference between the two. The process, I talked a little bit about it. You have individual meetings. Sometimes you have written submissions to mediators. Sometimes you don't. Joint session, where everybody can kind of bitch back and forth. They can talk back and forth. It gives you the parties the feeling of the day in court. That 1 hour session where people are across the table kind of talking at each other gets everybody's cathartic, I gotta tell you what you did bad to me, why you're a bad person and why I'm a good person. That actually helps the mediation quite a bit because you get your day in court. Then your separation for the negotiation, and then the shuttle diplomacy going back and forth between the rooms. I have one mediator that I've used, and he actually did the Microsoft mediation. He's done huge mediations that were worth tens of millions of dollars. He doesn't go back and forth. He sets up home base, and he has an assistant. And so you're in a room, and he calls you in. He sits there, he's got all the documents, but he's so good. But he's the king of the castle. So it's like, Hanahan, bring your team in, and then you talk, and then you leave, and then they come in, and he doesn't move. Most of the time, the mediators are the ones running back and forth. This guy doesn't. But he's good. He's really good. Mediations can be interrupted and continue. If you don't get it done the first day, that's okay. Maybe you come back later. Keep in conversations. It's a business resolution. And like I said, hopefully you try to resolve it. Settlements may occur during that mediation day or a later date. And if you get a settlement, you're going to write some type of binding agreement or contract. We had this mediation. We came to this decision. We decided that Hanahan has to pay Jones $500,000. And it's not going to be much more than that. But that is a binding contract that can be enforced. So the end of the mediation will create something binding if it's successful. Up until that ending, nothing's binding. I think that's it. Any questions? A little later than I thought because we had technical difficulties, but that's all I got. Anything? All right. I will see you guys next Friday. Like I said, Wednesday or so, I should have the lecture notes up on and this audio, but you don't have to go back and listen to this one later on if you don't want to. And this audio, but you don't have to go back and listen to this one later on if you don't want to. And this audio, but you don't have to go back and listen to this one later on if you don't want to. And this audio, but you don't have to go back and listen to this one later on if you don't want to. And this audio, but you don't have to go back and listen to this one later on if you don't want to. And this audio, but you don't have to go back and listen to this one later on if you don't want to. And this audio, but you don't have to go back and listen to this one later on if you don't want to.